Rehabilitation and Social Services will come to order. Thank you for joining us. Just a brief housekeeping announcement. The committee will deal with identical bills first, and if your bill is identical to a Senate bill, we will vote it out, and you do not need to be here. If you have a House bill that is similar to a Senate bill, I think I can confidently say that we will probably put a substitute on your House bill so it looks like the Senate bill, and you will be going into a conference committee. So we're not going to take testimony on identical bills or bills that are similar. Other bills, we would be happy to hear from the patron and probably take limited public comment because of our heavy agenda. So having said that, I am going to ask the clerk to open the roll.
You have a quorum, Madam Chair.
Thank you. The first identical bill on the agenda is House Bill 27, and the patron is Delegate Carlson, and it is identical word to word to my bill, Senate Bill 39.
Move to report. Second.
Okay, motion has been made and seconded. Will the clerk please? And it has to be re-referred to Finance, of course. Okay, motion has been made to report and re-refer to Finance. Please open the roll.
Ayes 10, no 0.
Thank you. Next bill is House Bill 522. The patron is Delegate Krizak, and it is identical to Senate Bill 182, and it has to do with alcoholic beverage control. It was the advertisement bill. It does not have to go to Finance. Okay, motion has been made to report. Is there a second? Okay, will the clerk please open the roll?
Ayes 10, no 0.
Thank you. Okay, next bill is House Bill 688. The House patron is Delegate Lethwich. The bill is identical to Senate Bill 635, Senator Rouse's bill, and it has to do with the alcohol beverage control sale and delivery of mixed beverages and pre-mixed wine for off-premises consumption. It also has to deal with our third-party delivery issue.
Move to report. Second.
Okay, motion has been made and seconded. The clerk open the roll.
Ayes 10, no 0.
Okay, thank you. Next bill is House Bill 1128. The patron is Delegate Bennett Parker. This bill has to do with the Children's Advocacy Centers. It's identical to my bill, Senate Bill 12. We defined a Children's Advocacy Center, and we talked about the use of such a center in various forensic investigations for children. Okay, motion has been made and seconded. The clerk open the roll.
Ayes 10, no 0.
Thank you. The next bill is House Bill 1498. The patron is Delegate Willett. This was a name change. The bill is identical to Senate Bill 173, Senator Craig's bill, and she renamed adult daycare centers to adult day centers, and it is the same bill word for word. Okay, thank you. Motion was made and seconded. Will the clerk open the roll?
Ayes 10, no 0.
Thank you. Okay, we are now on similar bills. House Bill 555, patron was Delegate Hope. It is similar to Senator Marsden's bill, Senate Bill 456. It has to do with the creation of an ombudsman at the Office of the Department of Corrections. I don't know what the differences are, but I think they can work it out in conference. This bill does have to be re-referred to Finance, so I need a motion to conform House Bill 555 to Senate Bill 456. Okay. A motion has been made and seconded to put a substitute on House Bill 555 and re-refer to Finance. Will the clerk open the roll, please?
Ayes 10, noes 1.
Okay, the next similar bill is House Bill 1269, Delegate Price. This is the Barrier Crimes Bill, and we did hear a similar bill, Senate Bill 626, sponsored by Senator Pillion. This has to do, as I think you all remember, about creating an exception to barrier crimes for employment. We need to conform this. It does not have to go to Finance. So I need a motion to conform House Bill 1269 to Senate Bill 626. The motion has been made and seconded. So we need to report this bill with the substitute. Has the motion was made? Could the clerk open the roll?
Ayes 9, noes 3.
Thank you. Okay, now this next bill is House Bill 1349. And I know Delegate Krizik is here, and I think after talking to stakeholders, we were going to just report your bill and not put a substitute on it. And our other bills, our Senate bills, are going to conform. So we're trying to avoid a conference. And I did have a meeting with stakeholders. Is that your understanding? Yes. Okay, thank you. I would like a motion then to report House Bill 1349.
Second.
Okay, thank you. Will the clerk open the roll?
Ayes 13, noes 0.
Thank you. Okay. Colleagues, this now brings us to other bills before the committee, which we will be taking testimony on. I don't see Delegate Hope, so I'm going to move to Delegate Delaney, House Bill 1366.
Good morning. So, Madam Chair, I do have House Bill 1366. This bill establishes a process for local departments of social services to conduct background checks for current or prospective employees, and it prohibits local departments from employing any person who has been convicted of a criminal offense that relates to their employment. I will note that the reason I bring this bill is failure to comply with this federal requirement could result in a $3.2 million fine from the IRS. So this bill would help the Commonwealth avoid any possible federal penalties and make sure that we can continue to process TANF requests.
Do you have any speakers?
I believe Mr. Ayers is here from the department.
Okay. And you're speaking in support?
Yes. Good morning, Madam Chair, members of the committee, Carl Ayers, Deputy Commissioner of DSS, and thank you, Delegate Delaney, for carrying this. She explained the bill. It's a 5-year-old audit finding that we've been at risk, and the IRS said you got to get it together or you're going to end up with this fine. So it's a one-time cost. You're not dealing with the cost this morning, but it's a one-time cost to bring everything into alignment, and then we can keep pulling down the records that are needed to process the TANF cases. So it should be a simple explanation for the bill.
Anybody wishing to speak in opposition to this bill? Do I have anybody on Zoom wishing to speak to the bill?
No, Madam Chair, you do not.
Okay. Yes, so the motion has been made to report and re-refer to Finance. And there's a second?
Madam Chairman,
Hold on. There's debate. Go ahead, Senator Servo.
I just have a question for council. David, I just looking at this, I see there's some barrier crime language in paragraph C, and is that consistent with the other bills we passed, sort of lifting barrier crimes for different types of positions?
Madam Chair, Senator Servo, I don't know that this was drawn up to necessarily align with that. Maybe we'll defer to Carl as to where they pulled this exact language from.
Yeah. So, Madam Chair, Senator Servo, this is actually language that was considered 3 years ago. So the bill has been here multiple times from that end of it. So the language has set from, I think, from 21, and it was drawn in conjunction with the Attorney General's office at that time. So it's the language has been before you, but the language wasn't changed this year. It was just a reintroduction of the bill. So that's the closest I can give you of why it doesn't look the same as the language they've been using this year.
Senator Servo?
Yeah, Madam Chair, so council, I'm just trying to understand if we're passing a consistent policy or an inconsistent policy with what we've passed in other bills so far this session. Like the barrier crime bill we just passed from Delegate Price.
Madam Chair, Senator Serval, I'm not aware of any conflicts that this would have at this time. I think it's fine. This is just for the employees of the local departments, correct? And as I understand, like, they just don't have a process right now. So this just gives them a framework for deciding whether anything they find during that background check should be a barrier to employment, as far as I understand it. So I don't think it conflicts with any of the other that I'm aware of barrier crimes that we have on the books or the ones that are going through this year.
Well, and I will just say that we have had different language nuances, if you will, depending on whether they were going to be peer recovery specialists, as you recall, for those leaving jail or prisons. We've had different language regarding their barrier crimes related to employment. So my only question is, I expect that this language is sort of uniformly used across the country. Is it recommended by the Association for Social Service Providers?
So, Madam Chair, and the best way I can explain this is this specific paragraph only deals with the employees of the department from that end of it. So in comparison, Senator Serval, I don't have a comparison for what you've done with the other pieces from that end of it. This specific paragraph only deals with employees of the local department, and it says that specifically if the information comes back, that's what we have to look at from the end of it. So that's the best answer I can give you without being able to compare it to the other language that you passed.
And the department's doing the screening, and the department will be holding the employee accountable, the whole 9 yards that you would do.
Yes, Madam Chair. And to give further context for this, we have been background checking TANF the workers that do TANF. The IRS finding said you have to background check all benefit staff. So this is an expansion of what we've already been doing. This doesn't change anything from what has been the practice. It just expands the population that we have to because of the way that the case management system works.
And it conforms with the IRS requirements.
That is correct. Yes, ma'am.
I think that's the important point. Okay, a motion was made and seconded to re-refer this bill, to report and re-refer this bill to finance. Will the clerk open the roll?
Ayes 14, noes 0.
Thank you, Madam Chair. Thank you.
Thank you. Who do I have next? Is Delegate Simons here? No. Is Delegate Seabold here? Okay. Is Delegate Gardner here? Okay. I think I'm going to ask one of my colleagues, or I can ask staff to present. Go ahead and text them, but in the meanwhile, I'm going to ask staff, General Counsel, to present the bill. We will not defeat a bill without the delegate being here, but we may be able to move things along. Mr. May, would you explain to us Delegate Seabold's bill, House Bill 159?
I will give it my best shot. Let's see here. This is about dogs. And the two different pieces. The first section is about state correctional facilities. Second section is about juvenile correctional facilities. And it's regarding the use of canines. So the rule for juvenile correctional facilities underneath the bill would be very straightforward. It says that it's unlawful to use a patrol or security canine in any juvenile correctional facility. It does say that this prohibition is not going to apply to the training or use of detector canines, and it will not prohibit use of a dog to find a juvenile who escaped. The rules for state correctional facilities are a little bit more complicated. Same general rule that it's prohibited to use patrol or security canines, but there are more exceptions here. The first is, unless the correctional officer reasonably believes that the use of the patrol or security canine is immediately necessary to protect any prisoner or any officer from a threat of serious bodily injury or death, or they have the prior approval of the warden or supervisor to use the canine to intervene in an altercation, fight, or other incident that involves 3 or more prisoners. And they have to try to give them warning if they can. B goes on to say that they have to make public their policies. They have to track the uses of force and make public reports regarding those canine uses. And again, you have the carve out that doesn't apply to training or use of detector canines, and it's not a prohibition on using a dog to locate a prisoner who has escaped. That's the bill, Madam Chair.
Thank you, Mr. May. Is somebody from the Department of Corrections here?
Good morning. Tish Rothenbach with the Department of Corrections.
Yes, ma'am. Go ahead.
Tish Rothenbach with the Department of Corrections.
Okay. Go ahead. Could you please speak up?
Yes,
Speak right
ma'am.
into the microphone.
We have no position on this bill. We've worked with the delegate to be able to conform our concerns and talk with them.
So you're in support of the bill.
We have no position.
You're not in opposition to the bill.
Correct.
All right. I think we heard this. It looks like a fairly good bill. It does
Madam
not
Chair.
have to go to finance. Okay. Let's take the comment online. Okay.
Mahan Raf, you may unmute and give your testimony. Please make sure your camera's
Please
on.
keep your remarks to 2 minutes or less.
Thank you very much, Madam Chair, committee members. Taj Manheft with the Humanization Project. Just to say quickly, because there hasn't been an opportunity to say, this is something that is a bipartisan effort to try to stop Virginia from being 18 times the second highest rate of people being attacked by dogs in prison systems. Something we do not want to be the outlier in that direction on. So it's just a simple human rights thing. We get reports constantly. And I have actually personally seen the scars that happen. We just want to make sure that it's done with the greatest care if it is ever done. So thank you very much.
Thank you. And I have a few speakers. Please be brief. Is this Kim Bobo from the Interfaith Center?
Thank you, Madam Chairwoman. Kim Bobo, Virginia Interfaith Center. We've worked with both Delegate Webert and Delegate Seabolt on this bill. It is a merged bill between the two of them, with essentially the part dealing with the Department of Corrections being Delegate Webert's bill, and the part that is the ban in terms of juvenile justice being Delegate Seabolt's bill. It was merged together. It's a very good bill that really addresses what is a Virginia dog problem. There were 295 dog bites in the country in prisons over a 6-year period. 271 of them were in Virginia. So again, this is not a national problem. This is a Virginia problem. And so this bill seeks to not totally outlaw the use of dogs in our main prisons, but it puts some limits on it that I think have proved useful in other states, and thus we think this is a really good bill and would be important to pass. So thank you.
Good morning, Madam Chair, members of the committee. Sean Winetta speaking on behalf of the ACLU of Virginia. Ms. Bobo spoke a little bit about some of the numbers. The next closest state, she mentioned 271 of those 295 were here in Virginia. The next closest state was the state of Arizona, which had 15 during that same 6-year period. A couple things just to sort of point to as far as training standards. Virginia State Police has a 520-hour training standard for a canine handler, which is significantly higher than that of Virginia Department of Corrections. They're also members of the Virginia Police Canine Association, and basically all of the state police, as well as also local law enforcement agencies here in Virginia, are members of that Virginia Police Canine Association, which the Department of Corrections is not. So there's some other just one last number I'll talk about. We evaluated all the bite incident reports from the Department of Corrections and matched them up with this policy if it's to move forward, and that would reduce, if adhered to by the department, would reduce the attacks or the dog bites in Virginia's prisons to probably about a dozen, somewhere in that network that would put us in line with other states. So we ask that you report the bill. Thank you.
Morning, Madam Chairman, members of the committee. My name is David Smith. I'm the Director of SALT, Social Action Linking Together, and we support this bill. We feel that it is a great first step for Virginia to align us with other states, and just reiterate everything that VICPP and ACLU have said. Thank you.
Thank you. Wonderful. Okay, motion has been made to report, and it was seconded. Will the clerk open the roll?
Ayes 14, no 0.
Ayes 14, no 0. Deborah Gardner. I know. I mean, I can hear the bill. We will not defeat a bill without the patron here. But we will take testimony, and if we're comfortable with the bill, we will report it out. If not, it'll go by. Okay, Mr. May, this is Delegate Gardner's bill, HB 472.
Madam Chair, okay, this is about, I should probably get to the bill in my book. This is about reporting, evidently, that has to do with child care services underneath TANF. So the members of this committee will remember a few years ago, we switched child care from DSS to DOE. In doing so, this reporting requirement shifted to DOE. As far as I understand, DOE is doing it, is required to do it, but we didn't remove the reporting requirement from DSS's obligations. So essentially you have two entities doing the same report. So this looks like it's getting rid of the report, but really it's just getting rid of DSS's obligation to make this report, because DOE is already handling it each year. And Carl, is that?
It's really a technical amendment then, because it's following our current law is how I read it. It does not have to go to finance.
Madam Chair, move to report.
Yeah, a motion has been made to report, and there's a second. Will the clerk please open the roll?
Ayes 14, no 0.
The bill reports. Okay, I think she will be happy. Delegate Simons, welcome. Are you ready? Okay, you've got House Bill 361.
Thank you so much, Madam Chair. The purpose of HB 361 is to provide clear authority for the Virginia State Police to release criminal history record information to DSS, Office of Background Investigations, for the purpose of screening individuals for licensure, employment, volunteering, and foster or adoptive home placement. I'm happy to take any questions from the committee.
Okay, do you have any speakers here? Is anybody wishing to speak in favor of this bill? Please come forward.
Anyone online wishing to speak in favor, please raise your hand.
Good morning, Madam Chair, members of the committee. I'm Sharon Lindsay, Associate Director with the Division of Licensing at Department of Social Services. The administration strongly supports this bill, and we thank Delegate Simons and the State Police for working with us on it.
Does anybody wish to speak in opposition to the bill? This does not have to go to finance. It looks very straightforward. A motion has been made to report, and there was a second. Will the clerk open the roll?
Ayes 14, no 0.
Thank you.
This has run into a little bit of an issue. He texted me, so I'm going to go ahead and start talking about it, and he might be able to join us. Delegate May, would you like to make a presentation on the House bill?
Yes, Madam Chair. Let's see. Okay. House Bill 103 does four things. The first thing it does, it says that regarding the Board of Local and Regional Jails, when it's promulgating regulations or adopting any policy, period, or guidance document, whatever it may be, regarding a minimum standard applicable to a local, regional, or community correctional facility, they have to include information about that in their agenda for their meetings of the board or any of its subcommittees, and they can't adopt it if they don't comply with that policy. The second thing it does is regarding the review of deaths of any inmate. I guess any procedures related to that, policies and procedures, not just regulations, this is going to require the board to comply with the provisions of the Administrative Process Act. It does the same thing for minimum standards regarding healthcare services. So any policy or procedure got to comply with the APA. Normally the APA process is limited to when you're promulgating a regulation, but this would apply that to policies as well in those two categories. And then the final thing the bill does is, I think this was a request of probably the board. It would provide that the board shall not find guilty a facility or its non-healthcare staff for a violation that's committed by healthcare staff that they bring in. Basically, this would say, as a jail or correctional facility, if you've satisfied your obligation to have the healthcare providers there and the healthcare services required there at the facility, then if the doctor or whoever is there does something wrong, that's not going to be imputed to the actual correctional facility. And that's all the bill does.
Current law, though? I mean, in multiple settings?
Madam Chair, I would assume that you are correct. I think they are comfortable with this language because it makes that very clear. But I think it was not requested by the board. I believe it was requested by the local correctional facilities.
I'm going to ask Mike Edwards to come forward. You represent the Board of Local and Regional Jails, and I believe this was a bill you have been advocating for.
Madam Chair, Mike Edwards on behalf of the Association of Regional Jails. I don't think the board wants me to speak for them on this. Mr. May accurately summarized the bill. The fourth issue, and I have Derek Almerode, the president of the Virginia Association of Regional Jails, here today to speak to the bill. If I could give him a second, Madam Chair, I'd be grateful. The fourth provision, your question is spot on, Madam Chair. There is a standard or a regulation at the Board of Local and Regional Jails that prohibits the board from finding the jail superintendent in violation for a decision made by a doctor or medical professional. But unfortunately, the board has violated that standard, and so we thought it important to bring this bright line language before you. The rest of the bill is critically important, too, as Mr. May summarized. The APA requirements are very important. We have a disagreement with the board over those provisions as well. The board thinks it's exempted from the APA. It's arguable at best, and we want to make clear that when the board is working on two of the most controversial issues it takes up, healthcare standards and death policies, that there's greater transparency. Thank you, Madam Chair.
Good morning, Madam Chair, members of the committee. I am Derek Almerode. President of Virginia Association of Regional Jails. I echo everything that Mike said in respect of your time. That is correct. It's a good government bill. It's transparent. It brings the board to the APA standard. And certainly, as a superintendent in a jail, my responsibility is to provide continuity of care, good health practice and care, and provide qualified medical professionals to provide that care. But if they make a decision, a medical decision, I certainly can't make. In fact, I'm prohibitive to making a medical decision. So, if they make a medical decision and that is found incorrect, we should not be held liable as the jail for that. That should be something that impacts another venue or another appropriate action. So that's where we are with that.
Thank you. Is this Ms. Hobbs?
Good morning, Madam Chair, Committee. Elizabeth Hobbs with the Virginia Sheriff's Association. For all the reasons Mike Edwards already stated, we support the bill.
I have been texting Delegate Hope. This is a little bit more controversial than perhaps the presentations may suggest. If we look at lines 45 to 51, we're making it very clear that the delivery of the health care and the treatment is certainly the responsibility and the liability of healthcare professionals. There was some concern on the part of NAACP representatives that the jail was not in any way held accountable for providing the care, in other words, for facilitating the care and whatever other role that the jail should perform. An amendment was worked on last night. We have not heard back from the stakeholders. Patrick Hope is trying to get to the meeting, but I see there's another speaker. Would you like to come forward?
Madam Chair.
Let me take this speaker, and I may just close out and carry this over and not have a hearing next week. But we're going to finish the hearing while we can, after our speaker in front of us speaks. Go ahead.
Yeah, thank you, Madam Chair. Talia Mallory, on behalf of the Virginia NAACP, also speaking for the Arlington NAACP, and I don't want to steal their thunder. They may be online. Are they on?
I'm sorry?
They may be online. I don't want to speak for them if they're on themselves. The Arlington NAACP?
I don't know if they're online, but you can certainly speak, and we will allow
Michael Heminger.
We will allow Mike Heminger to speak.
Okay.
Go ahead.
So as you already stated, Madam President, we do have issues with the bill in the current form. We do know that there is an amendment pending. The bill attempts to shift responsibility and accountability from the jail administrator to the medical provider. As some are aware, the Arlington branch has been fighting for justice for years on the behalf of those incarcerated at the Arlington County Detention Center. We believe this bill creates a loophole and for jail administrators to pass blame onto medical providers and to shirk the responsibility to provide adequate care for those incarcerated. Further, we believe the jail administrator who currently supervises the jail medical provider bears ultimate responsibility for everyone that is remanded to their custody. Due to racism, discrimination, and other systemic disparities, this bill will adversely impact Black and brown people. And there is more, but I'll leave it there if the delegate is not here. And that is all.
Thank you. Let's hear from the speaker on the virtual platform.
Amy Stitzel, you may give your testimony.
Good morning, Madam Chair and committee members. A warm welcome, especially to the new senators here today.
Good morning.
My name is Amy Stitzel from Arlington, Virginia, and I'm speaking as the NAACP Arlington Branch Legal Redress Chair. I'm speaking against the portion of the bill that limits the board's oversight ability to find a jail in violation of minimum health care
Excuse me,
standards.
could you turn your camera on, please?
What was it?
I'm sorry, it looks like it is on. Okay.
We do have a policy if we'd like you to put your camera on, if that's possible. Thank you.
I'm sorry, I thought it was on. I apologize. It shows the recording button.
We
Can you see me
understand.
now?
Yes.
Okay, try again. So speaking on behalf of the NAACP Arlington branch, Amy Stitzel again. So the proposed bill removes the incentives for the jail to monitor and correct healthcare issues or disputes in its jail system. The board has identified the health and mental health of people in custody as its primary concern in the last 2 board annual reports. In the latest board annual report, where the jails were found to be out of compliance with a minimum standard in 18 deaths, 5 of those were attributable to healthcare standards. And because these jails were found in violation, they had to take corrective actions. Those corrective actions included enhanced procedures to call 911, adding staff to monitor people in custody with mental health issues, adding nurses, replacing their healthcare provider, and adding mental health professionals. This bill removes the requirement for jails to take any of those corrective steps. It's been suggested that we can't hold the administration liable for the healthcare provider decisions and that this is done in other settings. But in those other settings, a person is not in custody of the government with no ability to leave. Does DOC have a carve-out for the prisons? Does our neighbor, Maryland, the Commission on Correctional Standards, have a carve-out for their jails? Further, the board is not holding the jail liable or negligent in a civil context. All they're doing is finding an administrative requirement that the jail has to take some corrective action if they're out of compliance with the minimum healthcare standards. We ask that you vote against reporting this bill, and thank you for your time.
Is there a question? Our delegate is here. Yes, I'm aware. Did you have a question?
Yes, ma'am.
No? Okay, Senator Craig.
Thank you. Delegate Hope, it came out 98-0 in the House. I went through the whole committee and then the floor. Was any of these questions raised during that process?
Not until, Madam Chair, not until the end that we get this, and I committed to work with all stakeholders to see if we can find a resolution. I don't want to start new precedent here when it comes to defining who's liable for certain activities. And I think if there's concern, I'd certainly view it as a friendly amendment just to strike that. I think the APA portion of the bill, the initial part about transparency, is very important to this bill, so it at least continues in that regard. And so if the committee was open, and I would support an amendment that strikes that language that starts on line 44, that new language.
New language that's in my sheet. It starts on line 45 in enforcing and goes all the way through the state standards. It's basically lines that are dealing with the health care. And that's your...
That's the objection that I've heard
the-
from stakeholders,
that's
and
what we
I
heard.
certainly, I think it's with all stakeholders. We think it's important enough that this bill continue with the APA, the transparency language. And so if we can't reach consensus on that line 45, new language, I would like to strike that from the bill.
So moved.
Madam Chair.
Okay, a motion has been made to strike that language. Let me get a second, and then I'll ask you to speak. There's a second. Okay, Senator Rouse.
Thank you, Madam Chair. I'm just curious that there was an amendment pending. Is the amendment pending affects this, or is something
No,
different?
there's no amendment pending.
Okay.
They had worked on language last night. There was no agreement. That amendment has not been offered.
Okay.
The only amendment before us is the amendment to strike that language. And there's a second.
And would the members who opposition had issues with that,
Striking that language would accommodate the NAACP's concerns.
Okay, thank you.
Okay, so motion has been made and seconded. All those in favor of striking the lines as presented signify by saying aye. Aye. Okay, Delegate Hope.
And just last word is I commit to accepting the amendments, and we'll keep the bill that comes out of the Senate.
We'll keep the bill as is. Okay, a motion has been made to report the bill as amended. Is there a second?
Second.
Okay, will the clerk open the roll?
Ayes 14, no 0.
It's 14, no 0. Oh,
Madam
okay.
Chair, did you take care of my other bill, 555? I think it was.
Yes, we did,
Good.
and I think I put it into conference.
Oh, did you? Oh, yeah, I didn't want to do that.
let me see, what did I do?
You didn't conform.
There's no hope for it.
We put a substitute on it and we re-referred
Madam
it to
Chair, I'm
finance.
sorry I was late. My vote was needed downstairs for some of your bills.
I'm sure it was.
That helps. That all.
Senate of Virginia, Richmond, Virginia.